Okay, well, let's get started. Welcome, everybody. My name is Bryan Zarou, and I'm the Director of Policy here at the Better Government Association. We are a nonpartisan, nonprofit news organization and civic advocate working for transparency, efficiency, and accountability in government in Chicago and across Illinois. Welcome to FOIA Fest, and our panel today is FOIA and the Policy Panel. There's a law for everything from what public records you're allowed to request all the way to the time frame a FOIA officer is supposed to follow up in responding to you. So what are those laws exactly? Why are they important? What does it take to reach the level of transparency in government activity that people deserve? This panel will discuss the Freedom of Information Act statutes, who the fighters for transparency are, how the legislation impacts the public and public records. With us today, a senior policy analyst and a staff attorney at Chicago Appleseed Center for Fair Courts and Chicago Council of Lawyers, Sarah Staudt. Merrick Wayne is an attorney on the FOIA team at Lovie & Lovie, a civil rights firm based in Chicago. Matt Kiefer is a data editor at WBEZ, Chicago's NPR-affiliated public media outlet, who'll be joining us soon. Jonah Newman, an editor at Injustice Watch, a Chicago-based nonpartisan, not-for-profit journalism organization focused on the local and state justice system. And Freddy Martinez, the director of the Lucy Parsons Lab, a charitable-based collaboration between data scientists, transparency activists, artists, and technologists that sheds light on the intersection of digital rights and on-the-streets issues. So today, I'm really happy to be here with all of you. This is actually my first FOIA Fest. And also, I'm really excited because I get to learn a lot from you guys. I'm very new to the FOIA world, so I'm very excited to learn from each of you, from your different perspectives. Today, we're going to cover the understanding of the FOIA statute. Some of you guys are going to talk about your experiences with FOIA. The Judicial Record, there is a bill at the state level here that will finally open the doors to the judicial branch with FOIA, so we'll talk about that a bit. And what can be better with FOIA? So first, we do want to kind of get a ground level understanding of what FOIA is, a brief history, who can FOIA, and the misunderstandings of FOIA. So for that, I'll take it over to Merrick.
Thank you very much, Brian. So the FOIA statute stands for the Freedom of Information Act. It originally came about in the federal government, and now all 50 states have some version of their own FOIA statute, whether they call it FOIA, the Open Records Act, Public Records Act, or the Sunshine Laws. And what it means is that all people are entitled to full and complete information about the business of government and those who represent them. So it means we are all entitled to access public records. In many states, it does not matter where you live. You don't have to be a citizen of the state. You don't even have to be an American citizen or even have been in America to have that right of access. Other states do curb who has access in a way, but at least in Illinois, anyone can make those requests. So it is. It's been around in Illinois for many decades. In 2010, the General Assembly here, they actually amended the FOIA, and they made it a lot better in many ways. But relatively speaking, from a legal perspective, a lot of FOIA statutes don't have a lot of case law out there. There's not a lot of court opinions, or at least higher level binding decisions. So it is still very fresh and new for many areas of the law when it comes to FOIA litigation, which is what I primarily practice in.
Brian, I think you're on mute.
Sorry about that. I'll keep it off mute. Merrick, to close off with you for a few minutes, can you tell us kind of some of the misunderstandings of FOIA, what people think they can FOIA, before I go to Sarah, who can kind of tell us what is FOIA currently? Yeah,
absolutely. So misunderstandings about FOIA is some of the big things that people aren't sure about whether they can get are records in the possession of a private business. So while you can't FOIA just any private business, if a business is contracting with the government to perform governmental functions and to conduct public business, you can get those records that are related to that contractual obligation. Another misconception is that if a government official is using their personal cell phone or their personal email account to send communications, that you can't get those. That's not true. The Illinois courts have recognized that if they were to allow that, it would be a way for the government to just do a complete runaround of FOIA. So there is still an obligation to go after those communications on personal devices and personal accounts because not everything is stored on the device itself anymore. So if they have a personal Gmail account, they still have to do that search. But ideally, government officials would not be using their personal devices and accounts to be doing these communications, and it would all be used on their actual public accounts that they're provided by the government. Some other big misconceptions in FOIA is that, so in all states with FOIA, they have a deadline for when the public body needs to respond. So for example, in Illinois, public body needs to respond within 5 business days. That is not always the case, and they are allowed to take an extension of 5 business days. They have that right by statute. However, after that, they can't take any extensions unless the requester actually agrees to the extensions. And I see this all the time where the government will just keep taking extensions. That goes beyond those 10 business days, or even their first extension, they'll ask for 10 or ask for 7 or just any other number. But if the government is ever going beyond their permissible extensions, they are actually waiving the undue burden issue. And typically when you're seeing them taking so many extensions, it may be because they're having an issue with compiling the records or finding them. But unfortunately for the government, if they are violating our rights, they cannot deny it as being too burdensome of a request to comply with. There are many other misconceptions, such as with the ongoing investigation exemption in Illinois. So while that might sound like if the police are conducting an ongoing investigation, they don't have to give over records, that's not necessarily true. The statute is actually sets a very high standard for the government to reach, where they have to show that disclosure of each specific record would interfere with those ongoing investigations. However, you very rarely see the government actually trying to take that step and proving that up. They just try and rely on the ongoing investigation using that blanket exemption, which has been repeatedly rejected by courts in Illinois. Another big misconception is with the deliberative process exemption in Illinois, where when the government is engaging in discussions that are deliberative and pre-decisional, there's an exemption that allows them to withhold that information. Courts have reasoned that they want people in the government to discuss openly without any fear of backlash when they are exchanging their opinions before policy is finalized. But we still see that redactions for that, and that exemption is used very broadly, and more broadly than it should. They cannot use it to withhold factual information, and they cannot use it to withhold anything that's a final policy. So very frequently, when they are discussing policies, it's going to be based on facts. So those facts we are entitled to know. Now, maybe this government official would say, here are some facts X, Y, Z, and my opinion is A, B, and C. So the opinion itself would be exempt, but not the factual parts. And that is something that the government definitely overreaches on. And the last big misconception that I have is that only people who can afford lawyers are able to bring FOIA lawsuits. That's not true in many states, including Illinois, where in Illinois, if a requester prevails in a lawsuit, their attorneys can actually recover their attorney fees from the government. So actually makes it very affordable for people, whether they're journalists, they work for nonprofits, or they're just your average concerned citizen, or maybe a person who's incarcerated and trying to prove that they're wrongfully convicted. The Illinois FOIA statute and many other states' FOIA statutes are set up in a way that is to make it easy for the public to bring these lawsuits. Because at the end of the day, this is about our right to get access to the government's information. And as everyone I'm sure is aware, litigation can get expensive, and it can cost a lot when lawyers get involved. But that's why the government ends up paying the lawyers' fees, because they don't want to hinder people from seeking their rights.
Thanks, Merrick. Sarah, also as an attorney, if you want to add to that, you're more than welcome to. But something I wanted to get with you was, what information can you not currently get with FOIA?
So there are a number of exceptions, many of which Merrick mentioned. Merrick really mentioned the biggest ones that are sort of categories of kinds of information you can't get. There are also some redaction laws that basically mean that, various kinds of personal information are not going to come through in your FOIA request. Other people on this call are probably better experts on that than I am. one wrinkle in Illinois in terms of who we can FOIA, though, is that our judiciary has exempted itself from FOIA. So, you all remember your 8th grade, I don't know, civics classes, right? There's 3 branches of government: executive, legislative, and judicial. And although the FOIA statute says that any executive, legislative, or administrative body is subject to FOIA, the judiciary, in a case called Copley Press versus Illinois, Copley Press versus the Administrative Office of the Illinois Courts, basically said, unless those administrative functions are judicial, and in that case, they aren't subject to FOIA. And there's been a string of cases after that that have basically carved out the entire judiciary, anything they supervise, and all clerks' offices from the ability to send a FOIA in Illinois. Notably, that's something that the judiciary did itself. It was not the legislature's intent. There's no reason to think that the legislature ever intended to exempt particularly those administrative functions of the court. There are obviously, that deliberative body, that deliberative exception is going to have a lot of implications in a judicial setting, right? Because there's lots of situations where judges are deliberating and you would be entitled to those records. But our courts are in charge of all sorts of things. In Chicago, I mean, everything from obviously all criminal, civil, and anyone who goes to court for anything, but also probation departments, the Juvenile Temporary Detention Center, mediation services, interpreter services, court reporters, everything you could, everything that is in any way related in many ways to the courts is exempt. So that's a very frustrating problem in Illinois. We're unusual among states, not totally unique, but most states have an ability for Freedom of Information Act requests to cover the judiciary, or if they don't, have some additional parallel rule that allows, request of judicial records. We have neither. So that's something that it's just something that in practice, if you're interested in any kind of criminal legal or civil legal issues, you have to find ways to work around under the current law, and hopefully soon there will be legislation to support that might change that.
Absolutely. And we'll actually get to that in a second, and I'll open that up for everybody once we get to the judicial record part of the panel. First, I want to get to Jonah and Freddy. And before we get to Jonah and Freddy, I just want to say to everyone watching, if you have questions, we are going to have a Q&A section at the end of this in about 30 minutes or so. So if you put your questions in the chat or the Q&A, we'll get to some of your questions. Let's get to Jonah. Jonah, so why don't you tell us, as a journalist, and Freddy, keep in mind for this too, as a journalist, kind of tell us what your experiences are with FOIA, some successes, some challenges with your FOIA requests.
Yeah, so I think obviously this panel's called FOIA and Policy, and I think there's policy and then there's practice, right? And I think in a lot of ways, the judicial, sort of gaping judicial hole aside, which we'll talk about in a second, I think Illinois' FOIA statutes actually are fairly strong in certain ways, right? We have strict, timelines that public bodies have to provide records in. There's other states I've tried FOIAing for, records in New York State. There's no deadline whatsoever. Years and years can go by before you get any records here. Here, if they haven't responded within 5 business days or another 5 business days, if they extend it, that's a denial, and you can file an appeal or file a lawsuit and take action. So I think in some ways we do have some measures here. I think to what Merrick said earlier, I think there are lots of ways that government agencies either skirt the rules or sort of exploit some loopholes that can make it difficult as a requester. So I think some common ones I've seen are some of the ones Merrick mentioned, right? Sort of blanket exemption, blanket denials or exemption, withholding of anything related to an open investigation, an open law enforcement investigation, even though the law says they have to, explain why releasing these records would be likely to actually impede the investigation. I see that one, fairly regularly being sort of ignored. I think, same with things like the deliberative process exemption. I once, I was looking for the Chicago Police Department, like many departments across the country, rolled out a body camera program several years ago. They did a pilot program first, and then very quickly, in the wake of the Laquan McDonald shooting, rolled it out citywide, and claimed that they had done some research into the effectiveness of the pilot program, and surveyed officers who were part of that pilot program. I went to request the surveys that those officers had allegedly filled out, and it was withheld under the deliberative process exemption, even though, it was the final survey. It was the results of the survey I was looking for. So, I think there's always sort of frustrations like that. I think the same with the thing Merrick mentioned before about, public records that are held by private companies that are doing business with state agencies or for state agencies. I think, I've had situations where, the public body says, oh, that's a record that this private company has, and they say they can't get it to us in the format you're requesting. Well, there's not a ton I can do to prove, but no, they have to have that. If the public body is saying, well, we can't do anything about it. And obviously they don't necessarily have that much of an incentive to go looking for records in the, that their private contractor actually holds. So, I think it's definitely a mixed bag. I do think on the whole, I've had, quite, good success getting public records in Illinois, getting things on time, occasionally having to file lawsuits or appeals, but generally I think, there's pros and cons. I'll turn it over to Freddy.
Yeah, no, I think you did a great job, Jonah. I will say that, in terms of successes, one of my pro tips to people, and I always joke that it's like the movie Memento, where you have to read the statute, sort of tattoo it into your body, because knowing the actual statutes themselves is a great way of pushing back and really using that as a way to successfully FOIA. So, for example, when Merrick talked about this unduly burdensome exemption, they have an obligation to meet with you first to talk about narrowing the request, which they never do. They never do. And that by itself is a violation of the FOIA. So a lot of my investigations usually begin with, fighting that exemption, filing a lawsuit, getting records, challenging redactions, and then using that as a way, I had quite a bit of success of using records that I've gotten from, one investigation, and then I know that a record exists because it's mentioned in another record over here, and then I go and sort of, I call it daisy chaining, but sort of going from one investigation to the other and building a corpus of records that exist and you have access to. So those have been some of the ways I've been successful. I will say a few challenges that are really frustrating that there's very little I can do. The first one is I call jumping the line, right? As a matter of statute and policy, everyone is supposed to get their records within 5 days, regardless of who they are. But as a matter of policy, agencies will always prioritize news organizations and will always, it seems as a rule, sort of have them jump the line. And I've seen this where you have, people like the mayor's office and CPD coordinating when they're going to get records to NBC, and they're doing 5 days, and then but they have a list of all open requests, and when they see my name on there, they just ignore it, right? So that's really frustrating. It's illegal, but it's done all the time. And the abuse of the exemptions, I will say that there's another abuse we talk about a lot less, and that's the lack of citations, right? You just get things that are black and redacted, and agencies are supposed to tell you which exemption they're applying for each instance, and they never do that, which makes it challenging because I don't know if they're withholding under deliberative process or because it's an open investigation. So I don't know how to, respond, to say maybe there's a privacy interest that we can overcome or things like that. So those are like the major ones that I think we don't think about as often, but those are probably the ones that I've had the most experience with. I found that my expertise in FOIA comes from having to apply the statute correctly, and knowing the statute and applying it correctly is sort of given me a lot of institutional knowledge. And so when I see these kinds of abuses, it's a really powerful way of pushing back and getting those records that you're entitled to.
Yeah, I second that. And just one other thing, I think that the other thing that's sort of on paper is strong in Illinois, we can talk about this a little more too, is, we have this state level public access counselor who's supposed to, mediate and when agencies don't follow FOIA, is supposed to tell them that they haven't followed FOIA. And I think I want to say, like, I think there's a lot of really good people working at the PAC, and I think they're doing, a lot of them are really trying, but I think ultimately it ends up being fairly toothless because most of their decisions are non-binding decisions. And I've had public bodies just blatantly ignore the public access counselor's ruling in my favor. They send an email saying, Jonah was right, you guys need to provide this record, and then, cricket. So I think, that's another thing that sort of on paper, policy-wise, is fairly strong in Illinois. In practice, could definitely be improved.
Let's talk about that for a second. And open up to everybody. If Merrick or Sarah, maybe there are people who are listening who are not from Illinois, and I'm not sure if a public access counselor exists in other states, but can you explain who the public access counselor is? Tell us a little bit about the abuses in the office between redaction abuses, exemption abuses, and what the enforcement level there is here in Illinois.
Sure, I can speak to that. So the public access counselor, it is a division of the Attorney General's office here in Illinois. In many states, regardless of FOIA, you'll see that Attorney General's offices issue opinions about the law. So this is essentially our FOIA equivalent in Illinois. So when your request is denied in Illinois, you have the option of either filing a lawsuit immediately or going to the public access counselor. And the issues with going to the public access counselor is that they can issue a binding or a non-binding decision. So Freddy and Jonah are right that you can win in front of the PAC and the government will still ignore you. And that typically happens because they choose to issue a non-binding opinion. The vast majority of their decisions that they release are non-binding, but there's even binding ones that the government won't comply with. And there's not really any other enforcement mechanism beyond that. Another issue that I run into a lot, since I represent a lot of people who are incarcerated, is that the PAC has a lot of discretion as to how much they will pursue when a FOIA request is brought to them. So very frequently, I'll see someone who's incarcerated. They submit a request to the police department or a state's attorney's office. They get denied. They go to the PAC on their own accord, and the PAC just says, "We're closing this matter." They don't decide whether the public body acted correctly or not. And there's just no other runaround that those people have, and all they can do is file a lawsuit at that point. So that's a big issue I see with it.
Am I right in saying, Merrick, that the public access counselor there's a statute of limitations between when their opinion is binding and then after that, and they usually wait till after that statute of limitations is over to issue, so it's non-binding? Is that a common practice here in Illinois?
What? If I could jump in.
Go for it, Freddie.
So yes, that is true, Brian. The thing is that they're supposed to sort of get the records from the agencies, review them, and if within that window, if they find that the agency had misapplied the law, then at that point they make a non-binding opinion. The problem is that agencies know that time window is tight, and they just don't respond to the PAC. I see this very frequently from a large police department in Chicago named the Chicago Police Department, and they never respond to the PAC. And they know that because they know that they clearly misapply exemptions, they clearly miss the deadline, all of that sort of stuff. And so that's why majority of the one of the reasons the majority of the opinions are non-binding is because agencies know that they can just run the clock out. And it's particularly frustrating because then you have to file a lawsuit. I will say that there is a really good use for the PAC, and that's for understanding. Sometimes they do a really good job of trying to figure out how an agency did a search, which is useful in terms of, when you want to go to court and talk about the reasonability, how reasonable the search was. Did they look for electronic records when I asked them to look for electronic records? All that sort of stuff is the kind of thing that the PAC could look into, even if they don't give you, a binding opinion. Having that information is also sometimes very powerful.
One other thing I'd like to add is that PAC opinions, regardless of whether they're non-binding or binding, they're not precedent for the court. So even if you lose in front of the PAC and you decide to file a lawsuit, the judge is not bound at all by the PAC. I mean, they can consider it as persuasive, but it's not mandatory. And there is case law out there that says that they're not bound by the PAC's rulings.
Merrick, I'm curious, have you found, do judges, when the PAC has, issued a determination in favor of a requester and then the agency doesn't comply and you file a lawsuit, do you find that judges tend to use that against the agency as, sort of reason to require them to respond?
Yeah, typically at that point, it's going to go in the requester's favor. But I want to say, at least in my experience, when we have those types of cases, after the lawsuit's filed, then the public body realizes that they're just going to comply. And we typically don't get another court order on top of that.
Getting into, thanks for all that, everybody. Getting into another topic here is the judicial record. Currently in Illinois, we have, as Sarah said earlier, the judicial branch is not subject to FOIA. We are an outlier somewhat within the country of not being able to access records in the judicial branch. So I do want to, just to give some background on what's happening in Illinois or what's not happening in Illinois, is there was a bill to try to get that going. Unfortunately, it's a dead bill. It's not happening this year, but it's something that advocates are going to try to push for next year. So I do want to kind of bring it over to Jonah, Freddy, Sarah, and Merrick. What are the benefits of having that judicial branch open to FOIA? What kind of successes could you have had in your journalism careers if you were able to have it? What things could you maybe have prevented from happening? So I'll open it up to Sarah first, and then we'll get into everyone else.
Yeah, so I'm not a journalist. I'm a policy analyst, and primarily I'm interested in keeping track of how the courts are functioning, and also getting basic information about how our courts are functioning with which to make other policy. So what's really frustrating about the lack of judicial FOIA is that it does not allow us basically any access to even aggregate case information about things like case volumes, case types, case outcomes. And that just makes it incredible. It means that even that legislators, to be honest, are really sort of, they're flying blind when they're making new rules for the judiciary. Everything from how much the judiciary needs funding to whether or not, if a new regulation is brought forward on the judiciary and the judiciary says, well, this is going to be too burdensome, there's sort of no way to check that work. And so I see in the chat a question, a point about case info, and that you can get it unsealed, and you can, but only by individual case. It's a lot easier to get information about an individual case than it is to get the kind of information that I'm talking about, which is general information about how our courts function.
Mm-hmm.
Those are the kinds of things that have really been frustrating to me.
Yeah, I mean, I'll jump in here. This has been a pet project, or pet peeve of mine for a while, and it started when I was at the Chicago Reporter and reporting on juvenile detention and trying to get some information about the Juvenile Detention Center here in Chicago, which, as Sarah mentioned earlier, falls under the auspices of the chief judge of the Cook County Circuit Court. Obviously, not actually a judicial function, right? It is it's a detention function, but those records are not subject to FOIA. So, I had filed some requests with the Office of the Chief Judge. Eventually, I did actually get data back then about how often kids in the detention center were being confined to their rooms or sort of put in what we would colloquially think of as solitary confinement. But I've never been able to get that data again because I got it, I wrote about it. But now that, they know that, I think, and they are under no obligation to do that. There's a whole list of things that fall under the Office of the Chief Judge that were they to fall under any other public agency or public body in the state or in the county, they would be subject to FOIA. But because they happen to fall under the Chief Judge, they're not. So Chief Judge has an entire pretrial services division. They have an electronic monitoring program that exists separately from the one that's operated by the Cook County Sheriff's Office. The Cook County Sheriff's Office has to release data on the electronic monitoring program. The Chief Judge's office does not. There's some almost 3,000 employees who work under the Office of the Chief Judge. You can't get any disciplinary information about them or personnel records of those employees, even though their salaries are paid by public tax dollars. Judges are some of the highest paid public employees in the state. I think starting salary for a judge is like $180,000 a year, and it goes up from there. Even after they retire, they get pensions for life, full pensions if they've been there long enough. And you can't get any information, about those judges. Another recent example, about a third of judges in Cook County are appointed as opposed to elected. And so, they're appointed by the other judges. And in order to, submit your name for appointment, there's a whole application process. And we just recently asked for copies of those applications for the latest round, which would open up lots of information, and any other political appointee to any other public office, you'd be able to get that, but because they're judges and they fall under the judiciary, you can't. So I go on, and it's something that we cover a lot at Injustice Watch, is the judiciary, but it is a major problem. I mean, it's just a gaping hole in the Illinois FOIA.
Yeah, there was a story that I.
Freddie,
go ahead, Merrick.
Oh, go ahead, Freddie.
There was a story that I worked on state's attorneys seizing people's properties who had not been charged with, not been convicted of crimes. And we spent a year and a half trying to get aggregate data from the state's attorney's office. And the only other way to get data was to sit there and court watch. And, we learned quite a bit over that year and a half long battle, but and court watching was helpful for the reporting, but still, to try to get aggregate data, you would have to sort of sit someone there for a week, 2 weeks, 3 weeks. And we were doing this as freelance journalists. It's at some point becomes resource prohibitive. So being able to access those kinds of records would have been great. And the other way that you can get data is, collecting it with a scraper or with, some kind of you have to write your own tools, which not everyone is capable of doing. That I know that's another challenge as well. Is like, well, can I put it from the clerk's website, which didn't exist even until a couple of years ago, right? So there's a lot of challenges there where technology might partially solve it, but really the solution is to require access.
Yeah, I agree with everything that people have said. The one point I just want to emphasize is that in our own FOIA statute in Illinois, it's like the declared public policy that having access, allowing the public to access public information about the government, and enables us to fulfill our own duties as the members of the public to make informed political judgments about those who represent us. And judges are elected positions. Even when they get appointed, they still have to run for retention. And so it factors in, you may not be able to make informed decisions when you're voting, and you have to rely on organizations that rate judges as qualified or not. But even so, to a point that Sarah made, if you want to talk to your representatives in the General Assembly about the FOIA statute and how it can be expanded with judges, or just not even FOIA related statutes, but those dealing with the courts, you can't make those, it's harder to make those informed political judgments if you can't FOIA the types of information that Jonah and Freddy were talking about.
I think there's also just one more thing. The other problem is that FOIA is useful not just for sending FOIA requests, it also incentivizes government agencies to keep their records in a way that is functional because they have to respond to FOIA requests, right? So the other problem that I've run into in the judiciary is like I work enough with some of these folks that like I will ask them internally for records and I truly believe them that they don't have them. But the fact that their record keeping is so poor is in part a function of the fact that they've been exempt from FOIA for so long that they've had no need to ever create functional systems.
Awesome. One thing I want to do is kind of finish up on our last set of questions, which I think we've answered a lot of it, and then I want to head over to the Q&As. I think there's some good questions in our chat, and if you have more questions, stick them in the chat, and we'll do our best to get to them. Besides, obviously, opening up the judicial branch to FOIA, this is open for anybody. What are ways in the Illinois law? What ways that we can improve FOIA going forward? Merrick?
Yeah, I have plenty of things on this one. You know, I think one of the biggest issues that's missing from the FOIA statute is adequate search and the obligation the government has to perform an adequate search for records. So this is currently it's enshrined in our case law from the courts, and it's based off of federal case law primarily, but there isn't an actual codified statutory duty that lays out what the government's required to do in their search. Currently, it's left up to judges to decide whether they've performed a search that reasonably contemplates reasonably contemplates where the records are likely to be held. So they don't have to perform an exhaustive search. They don't have to search in every location. Currently, the government just needs to submit an affidavit that to a judge appears that they have looked in the reasonably likely places. But, you know, what does that mean? Are they explaining where they searched, why they searched, who did they talk to, what search terms did they use, how are their files organized? Can they search by keywords? Do they have to search by some other categories? So there's a lot of information, and since it's not codified, you know, the public bodies can get around it. And also, kind of going back to the point Sarah was making about how the courts have unorganized records because of FOIA, without having a codified search requirement, they may not have the best tools for performing those adequate and reasonable searches. Some other issues that I run into a lot. So in the FOIA statute, some exemptions, the government only has to show that a scenario could occur, and other exemptions have the word would in it. So courts, this has been going on for a long time in federal courts, and now very recently, we've gone to decisions from the Illinois Appellate Court in Chapman v. Chicago Department of Finance and sometimes v. Chicago Transit Authority that is making it clear that in Illinois, would is a higher standard than could. So this is very critical for the ongoing investigation exemption. So it says that they have to show that it would interfere with an investigation. And so they have to provide specific evidence to show that. While you may see the exemption for public safety, which says that this is like for terrorist attacks, or, you know, it's a pretty broad thing that the government uses because that exemption says could reasonably be likely to lead to someone facilitating an attack on our public systems. So that could right there makes it a lot easier for the government to claim terrorism over broad swaths of records to withhold them. You know, another big one is heightening the penalties provision under the FOIA statute. So currently, if the public body willfully and intentionally or otherwise in bad faith violates FOIA, then the courts can levy a penalty against them of a minimum of $2,500 to a maximum of $5,000. Now, the legislative history, when you look at it, this is when Madigan was the speaker, but he was on the House floor saying, we want to impose stiff penalties. And, you know, 5,000 to some people may not sound like a stiff penalty, especially when there is this higher standard of willful and intentional or in bad faith. And now we have courts that are interpreting it to be willful and intentional and bad faith. So they're making it even harder to get penalties, while the whole point of penalties is to prevent the government from abusing the statute. I know Freddy and Jonah, they pointed out a bunch of areas where the government has abused FOIA and treated people poorly in that. And if you have heightened penalties, that can be curbed, especially the example Freddy gave where, it feels like that they put him to the bottom of the list when they get a FOIA request from him. I even feel that sometimes from public bodies. And, it's hard to prove that. It's hard to prove that the FOIA officer has some negative animus towards the FOIA requester. But if that can be proven, that's a willful and intentional bad faith violation right there.
Yeah, I think just on that point, I think I sort of approach FOIA knowing, right, that like a FOIA officer is probably never going to get fired for withholding a record from you that they should have released. They could possibly face repercussions for releasing something that they were not supposed to release, right? So I think, knowing that and knowing that that's where the incentives are, I think that certainly colors my experience as a requester. And I think, even changing those incentives slightly to make it clear that, there are actual implications or penalties for violating FOIA, I think would help. I think another thing, that Freddy mentioned earlier is really strengthening the enforcement mechanism, right? I think the fact that we've got, law firms like Lovie and Lovie willing to bring lawsuits and make especially city departments pay when they violate FOIA, I think is great. But I think having a non-court enforcement mechanism in the PAC that actually had teeth, right? And maybe it's by creating timelines by which the agency has to respond so that the 60 days that the PAC has to issue a binding opinion would actually be meaningful, right? Or maybe it's creating some sort of penalty or disincentive for public bodies to not respond to the PAC after they've issued a non-binding decision. But I think there are definitely ways that process could be improved too.
I'll be quick because I know there's some questions. I think of FOIA as a law of mandatory disclosure, and I think agency officials don't treat it that way. So I think attitude is obviously a big thing, right? And you see that in a lot of different ways. The interpretation of the word reasonable, right? When you're a requester and when you're a FOIA official in CPD, that word means different things, right? But if you view it to a lens of a law of mandatory disclosure, I think really would help. But other things that I think would be helpful is making it clear that structured data like databases are not exempt under FOIA, which is the case that Merrick was talking about in Chapman v. Department of Transit or Department of Transportation. So electronic records and bringing a FOIA statute up to the 2022. Expanded access to FOIA officials. So right now you have the situation where a lot of FOIA officials have to go to someone else and ask them to search for records. And actually the delay is people bothering other people to do the search. And so, maybe there's a way to expand access to electronic records for FOIA officials. And then finally, FOIA case law is weird because, you're deciding on what is and what isn't exempt in sort of a binary. But really, I think the FOIA is about the public's right to know information. So there should be some kind of public interest balancing test, I think, that says that even if something is exempt, even if you meet all of the requirements of the statute, but this information is of critical importance for health, public safety, or whatever, that it should still be releasable. I think that would go a long way. And finally, I don't think the deliberative process privilege should even exist because the entire point of governance is that you're deciding how you make decisions anyway. But anyway, that's my personal beef, and I'll leave it at that.
That's awesome. Thank you guys so much. I'm going to get to the questions because I know we only have a few minutes left, so I'll start going through these questions here and feel free for anyone to chime in on the answers. First question, can the attorneys recover fees if the suit is against the state's attorney's office?
Yes.
Yeah.
I can tell you from personal experience, yes.
Oh, well, perfect. Yes. So what can I do if our circuit clerk's office is not making information public that should be made public?
Unfortunately, not much.
Well,
At least right now.
There's a federal law of public access, which is not related to FOIA, but there are federal ways of bringing lawsuits to get access to information that should be public. It's a little bit wonkier than this topic, but there are some ways. But it's very challenging.
Freddy, am I correct in my understanding that anything redacted on the records obtained by FOIA needs to have a reason, and the agency must tell you why exactly it is redacted? Or, I mean, Freddy or anybody who has the answer.
Yeah, well, so Section 9A of the FOIA statute requires the government to provide a detailed written factual basis for their withholding. And I think, Freddy or Jonah, one of you talked about how you just get the black bar, it doesn't tell you which specific one. So in federal FOIA, those FOIA officers actually do tell you which one, but that doesn't occur in Illinois. Now, after you file a lawsuit, you are entitled to getting an index that has to describe the records and explain the reason for withholding. But if you're just filing the request, it can be very hard to get that. And you'll probably just get like a cover letter that explains it.
I will say, like, you can push back though, because it shouldn't. I mean, the statute doesn't say, only once you file a lawsuit, right? Like, that's supposed to be part of their response to your initial FOIA. And so if they just give you a blanket, hey, we've exempted all of this under, we withheld all of this under, the deliberative process exemption, like, you can ask for, specific reasons why the redactions are. You may not get it, but at least that's, it puts sort of on the record that they have already failed to really, provide an adequate response to your FOIA.
And one other thing, in case, just to make sure I'm answering everything that this question could imply, public bodies so the exemptions are actually optional. It's at the discretion of the public body. There are some that are mandatory, juvenile court records, there's mandatory prohibitions against that. But for the most part, with deliberative process, the ongoing investigation, for most of these exemptions, it's discretionary. And the statute says that the public body may redact the information if it's exempt, but if it's not covered by an exemption, it must be disclosed. So they can't just go around redacting other stuff just because they feel like it. They actually have to have a basis to do it. And all exemptions are narrowly construed in favor of disclosure, because that is the purpose of FOIA, is making the information public.
Awesome. Could you speak to FOIA restrictions on prosecutors' records?
So it's going to be fact specific to the records themselves. So State's Attorney's Office, they are subject to FOIA. I have seen many FOIA requests go to them. You're going to run into a lot more. If you're dealing with like the actual prosecution file, you're going to see stuff, redactions for people's date of births, home addresses, if it's witnesses, undisclosed witnesses, that information can be withheld if it would reveal their identity. If there's handwritten notes by the state's attorney, the prosecutor, that can be withheld under attorney-client privilege. But, court transcripts, they have to turn those over. They have to turn over pleadings in the file. They have to turn over the police reports they have, the lab reports, any other investigation, any witnesses that, testified at trial, and they're not disclosing their information by turning over through FOIA, you can get that. So there are plenty of records you can get from a prosecutor. And here's the thing, submit your requests. Worst case scenario, they say no and you don't get your records, but that's the position you'd be in if you didn't submit the request. So it's better to just do it and see what they give you first.
And the more they say no is the more that we can try to eventually change the rules on those things that they say no to, right? And Sarah, sorry, I didn't see your comment, but prosecutors are fully subject to FOIA. As Sarah says, they have been ruled to be an executive branch agency. That's good. That's really good to know. Are the judges still subject to a subpoena?
Like judicial records? I mean, they can be if you've got pending litigation and your subpoena is relevant, but that requires a lot that your normal FOIA request is not going to have.
Okay, I'm sorry. I'm just scrolling through these. If the state's attorney allowed us to view the file and internal emails, does that mitigate the deliberative process exemption because a third party has seen them? I don't know if that's if that's something.
So yeah, that can be. So if the communications involve someone who's outside the government, that can waive deliberative process. That's typically, you'll see that with people being copied on emails. And this issue was addressed in Chicago Public Media v. Cook County Office of the President last year, where the public body was discussing with people who were outside of the government. So it was they were discussing with a media consultant who was retained by a politician's political campaign. So they weren't actually retained by the government, and they were sharing opinions, deliberative, I guess, opinions about Wikipedia edits and statements made to the media. But since this person wasn't actually retained by the government, or at least the government never presented any evidence that they were retained by the government, they couldn't withhold that under deliberative privilege. Same thing if it's an attorney, an attorney's information where they're giving legal advice, that's going to be subject to attorney-client privilege. But in that same case, they were also speaking with the attorney who was retained by the political campaign. So again, it wasn't actually attorney-client privilege because they weren't giving advice to the government. They just were copying an attorney on an email and trying to claim privilege over that.
There's a rule in FOIA, which I like to call the no take backs, which is if a record's released, it's released, right?
What?
And it doesn't matter how.
Freddie,
it was released in public.
is he? Can you guys understand him on your end as well? No. Okay, so it's not just me. Freddie, give us a second and try again. Unmute. Is it? There you go.
Sorry,
Try again.
I'll put it in the chat.
Sorry, Freddie. Okay, so thank you everybody for that. I just do want to go around if anybody wants to give any closing thoughts before we sign off. And Freddie says there is a rule that there is no takebacks if a record was released accidentally. It still was released. Oh, okay, that's good. I didn't know that either. That's good to know. Does anybody want to give any final thoughts on FOIA and policy before we sign off? Awesome. I do want to let everyone know that the Better Government Association is the Illinois chapter of the Freedom of Information Coalition, which is a nationwide association of open government organizations. And we will have on our site within the next month or so an Open Gov page, which really explains FOIA, how to do FOIAs. We'll have a question and answer with the BGA on any questions you have. And then we do want to keep some sort of repository as well of who's FOIA'd throughout the state and who's not getting things back. So that way we can try to strengthen our FOIA laws here. So that's a plug for the BGA. And thank you to our great panel. I think this was really informative. And I can't wait to come back next year. Thanks, guys.
Thanks, Brian.
Everyone. Thanks, Brian.